Hi all, my name's Tom and this is an update for the events that happened on the 1st of May 2015. We left the house about 9 o'clock and people started arriving to protect my family home while Sue was holding fort, so to speak. And I believe there was about 60 to 70 people here. I don't know because I didn't see the majority. But the reports from the neighbours have been excellent. Everybody here was so well behaved. They couldn't commend the people that came here anymore. They were brilliant. And Becky at the pub, she opened up very early to allow them to use the facilities, the toilets. She made bacon sandwiches and there was refreshments for them, and it was a fantastic time, and they stayed right to the end of the court case. Now, it wasn't very warm, and I can't thank all of you enough for looking after my Sue and the house. So, thank you. And during that time, down at the court, a huge amount of people arrived, and once again they were in the same vein as those at the house, so well behaved, absolutely brilliant. There was a little bit of trouble, but that was because of G4S, who one of them attacked one of our supporters and got himself rightly arrested, and well done to the police for actually doing their job. And that was the chant that was heard by the judge. He thought it was directed at him, but it wasn't. It was for the G4S. And I believe there's two other G4S that might have criminal proceedings taken against them. The male wrongly told a different story, that the court was being stormed. Total nonsense. So if you're listening, whoever the one responsible for that story, retract that, tell the truth, and you did well before, but you blotted your homework book. So do the right thing and post a retraction. Now, these people came from every part of these islands, from Scotland, Ireland, Wales, up and down England, from Bristol, all along the south coast, London, Newcastle, Hull, I can't forget Manchester and Liverpool and Birmingham. Absolutely fantastic, you people. We owe you a real debt of gratitude. You did something that is remarkable. You allowed us to get into court, because without you, I wouldn't have had that opportunity. They would have simply railroaded us straight out, probably smashed down the door, as they do, totally unlawful, and I'd be having to come back and take it again. But you gave us our opportunity in court, and we'll be forever grateful for each and every soul that came along. Not only those that came along, but those that sent good wishes, and yes, just absolutely everyone. A special thank. I don't normally thank people individually because there's so many to go through, but there was a banner over the bridge. Now, I'd like to thank the council for building that bridge to the specifications of Henry, who produced the banner. It fitted very nicely. So, thank you, Henry. You're a hero. Okay, now up to the court case. The judge has now deferred his decision, and he's going to send it to me by email, and I'll let you know what the results are. So let's proceed with the court case, and I'll put before you some of the evidence that we put, and nearly all the evidence that Bradford and Bingley brought to the table. So the court case is all about an endowment that was changed, and there's not enough money. in the pot because we paid our bill, and they say it's not enough. They want the same amount again. This document, I'll start off with this one, a bit light-hearted. So they made an offer. They accepted our offer, and there you go. That's the offer on the 28th of September 1988. Now, if you see that, you think, yeah, that's nothing unusual. But Bradford and Bingley can time travel. They're in the same realms as Doctor Who, because they received it, as you can see there, on the 3rd of September, 25 days earlier. Fantastic company. I wish I could do their tricks and I would go back and not take this mortgage out with them. That was basically... Now I'll run it up so you can freeze frame it whenever it's necessary. That's the details. We're supposed to pay this, and that's what they do. And if there's a Myris, and then as you can see, I'll bring it now. I've highlighted it. That's Bradford and Bingley Building Society's endowment scheme. So now you know it's an endowment scheme, in case anybody had any questions about that. So, I shall put forward Bradford and Bingley's evidence. I asked them to bring many things to the table, like accounts, proof that there was actually any merit in their demands. And this is what they produced. Statements. As you can see, 1988, that's the very first statement. I would like you to take special attention to the account number. Now, as I go through, I'm not going to put them all up because it's 25 years. But it's the same account number as we go by for each year, all the way along. Okay. So as you can see, they go on and on and on with those account numbers. So when I was there in court, the reason why they produced those is because I previously told them that we had no accounts, no statements. Didn't have any. We generally threw them away. Foolish, but I didn't think we'd ever need them because we thought they were honest. So, 1988, we produced this in court. Our statements. And the barrister nearly fell off her stool and had a shaking fit when I pointed it out. As you can see, this is the old ones with proper, good quality paper, 1988, and I'll come down here, and where my finger is, it's an endowment. So now you've got confirmation that it is an endowment, but look at the account number. It's totally different. There are a lot of similarities in digits, but that isn't the account number that they put in. Nor that one, and that is the next year, I think it is. I didn't have many because I only found a few, but as you can see, they are all the same account number. Each and every one of them. I don't know what year that is. I think they've gone past the 92. So now you know there's a huge error in the documents that they put in. Whether those documents have been accidentally manufactured, I'll leave that to you to decide. But the other thing is that there is the DNA of any account. You try putting money into any account that with the wrong account number, and it'll go missing, or the bank will claim it. So now we come on to the main concern of it all, and that was when it changed. As you can see, that was endowment. Well, they wrote to us let me just put my glasses on and I'll read this one out for you so you get the gist if you don't want to freeze frame each bit. So, we have spoken on the telephone about your mortgage account. I am so sorry you had to contact us with your concerns. This is certainly not the standard of service we aim to give our customers. Starts well, and we thought it was good. I cannot apologise enough that your account is currently on a part endowment, part capital, and repayment basis. I've checked through my records, but I am unable to find any instruction from you to change your account into a capital and repayment basis. And then it goes on to say they'll give us £5,000. Well, let us pay off £5,000 because there was a difference, and they wouldn't charge us interest. I'll take that down for you so you see. There you go. I hope you can see that. Right, that's their apology, and I will also say that that account number that they used, another one very similar about this time turned up. And where these account numbers are coming from, well, I'll let you be the judge of that. So it goes on to the next page. I realise this must be very frustrating for you both. This has not given you a good impression of the society, and I hope this arrangement, that's the £5,000, about, it's less than that. Actually, it's £4,397. I hope this arrangement can go some way to restoring your confidence in the society. May I assure you, this does not reflect our usual standards, and as a gesture of goodwill, I am sending you a courtesy gift of the society, and if I can be of any more assistance, blah blah blah. And that's where they sent us the champagne. I hope you can see it. I hope I'm doing this correctly. And Mrs. Weaver signed it. So, now you know. There was an endowment, and it disappeared, and it ended up being changed by them. And then, in 2002, once again they wrote to us. On checking our customer contact department, they do not appear to have ever received a written authority for the above. Therefore, your account does unfortunately remain on a part endowment, part repayment. As you can see, if I can put it up correctly, there is the date, 2002, and oh, there's their apology again. So, now, well, it's not an apology, but it's an admission that they've never had any change in the contract from us. So we come to the case. Now, Michael, who assisted me, that's Benicia, he put this in, which is exceptionally, it's actually brilliant. Once I find it, so I'm not too clever then because I've lost it. This is the unfair trading terms contract, 1977. The Unfair Terms in Contracts Act 1977 states in section 10, a person is not bound by any contract term prejudicing or taking away rights of his which has arisen or connected with the performance of another. Another contract, so far as those rights extend to enforcement of another's liabilities, which this part of this Act prevents that other form of excluding or restricting. So, layman's terms, basically, the 1977 Act clearly prescribes the new contractual terms cannot be used by any party to evade the obligations incumbent upon him or her or them under the terms of the preceding bilateral contract, regardless of the nature. I couldn't do it, they can't do it, and they shouldn't have done it. So, they've admitted that those terms and conditions were changed by them, but not by us. And if they force the issue, then it comes to the Law of Provisions, Miscellaneous Act 1989. That act states that the deed must be signed by both parties. The contract must be signed by both parties with the terms and conditions and all the other parts that go with it to make it a legal binding deed. Without them, you can't use it. As Michael proved in Newcastle when he put this forward for his father and won a remarkable case. It's now case law. So he was and is the highest authority in that. So once again, they're stuck on that one, so they can't move out of there. Now there's one other one which I'll bring in, and this is the capitalisation. Now the Bank of Scotland was highly censured because of this. This is the Macready case, and they capitalised the interest. They admitted that not the interest, capitalised any debts. So if we'd gone over payment and they fined us, basically, any movement on that to charge extra money, then put it on in the mortgage again, and then charge us again for it. It's double dipping. So they've been censored for that, the Bank of Scotland. I don't know what the outcome is, but I don't think it's very good. I mean, they lost that case because of that. Right, so now you know they changed the terms and conditions, and they were stuck with the 1977 Act and the 1989 Act, and they capitalised it. Now, what I suggest you bear in mind, let's say this was a criminal case, which is plain and simple. I'll explain it like this. Let's say somebody's crossing a zebra crossing and he gets knocked down by a driver, and the police come along and arrest the driver, and now they can charge him with attempted murder, or if it's accidental, manslaughter. And the man says, could be a woman, I don't know, I didn't mean it. So the police may take that as an admission and charge him with manslaughter, and he'd get a very serious sentence for doing it without care, due and attention, taking a life. And the other one, the murder, would be even more serious and even a longer prison sentence. Once that procedure had gone through in the police station, they would have said, I'll write this down, will you sign this? It's a confession, and they would sign it. So let's say that's an end of the matter. This here is Bradford and Bingley. They've admitted here they've damaged my family. They've changed the terms and the conditions and the contract without our consent, and they say it wasn't their fault, no due care and attention, and they admit it because, oh, that's the wrong one, sorry, that one, and then they they admit it. They sign the confession. But in this case, the victim has been made to pay. So I'll leave you to judge if our case has got any merit. We asked them to bring their books. They didn't. We asked them to bring evidence. They didn't. They brought statements and scratch cards of conversations on the phone which could be made up from anyone. Right, so let me know what you think. If we're guilty, or we have no merit, or the bank is guilty, then they have no merit. So there's your case. Now, talking about the case, they got a possession order, and they applied for it. This is a claim for a possession of our property, and as you can see, there's very little detail there. No seal. Every county court should be a court of record and have a seal. That's an embossed stamp. As you can see, there's no title deeds for the house that they're coming out after. That isn't sufficient either. And there's no service address. They have a fee, but no fee stamp to say it's been paid. That isn't worth toilet paper. I could use the toilet paper. That I can only burn. It's nonsense. The Nottingham County Court proceeded with that case. That, I guarantee, came out of the solicitor's offices. Didn't come from the court. It isn't a court document. That is the casement file. That is the DNA of the case. Everything that happens goes into the computer and is registered. As you can see, there was no fee paid. The only fee that was paid in the casement file, I've got many pages, what happened, this is our payments, always registered. There's another one. The first one was £50, that's £135. You can see they do register the payments. I won't go through them all. So we'll come to the final one. The case started and they issued a so-called warrant. It's a forgery. That there states that there was no judgments and there was no warrants. And it is recorded, and that came out a week before I went to court. So, as you can see, this case didn't actually get into court. What it did get into, it got into a shadow court that does not exist. You accept these courts, you go into a little room, and they steal your property. The solicitors don't pay fees. They simply process the so-called claim. I asked them to produce the receipt. Now, the judge said they would have paid online. What that has to do, is he defending them? Is it his job to defend them? Well, they didn't pay online, because if you buy anything off the internet online, you will get a receipt. They'd have to get a receipt to use for tax purposes, to either claim it or to pay it. So I do not think they are telling the truth in the courts or in the solicitors or in the banks. If I'm wrong, why didn't you prove it in court? I've asked many, many, many times for that information, and I got waffle, but I didn't get the receipt. Okay, so that's basically it. That's the case done for now. So I hope you got to grips to most of that. It's I'm sorry it's a bit long-winded. I did cut it right down. We've got more evidence, but I hope that's going to be used in a criminal matter later on. So I do thank everybody once again. I said to a few people, I've run out, well actually the T on my computer is worn out for me thanking people. So my final time on this video, a debt of gratitude is owed to everyone who came every time, not just this time but every time. And we've got to grow, we've got to stop this corruption, we've got to protect our people. So, You take care of yourselves now, and thank you. Bye for now.